walk away from people that you know, that you've had a conversation with, you know they're trying to establish a claim here. They've talked to you previously. Mr. Ritter said he talked to him previously and was trying to establish a claim. He said he put out these posts out there and that they gave notice of his intent to stake a claim. And they told him they were trying to get that. When they came up and had papers and wanted to try and tell him about it, he walks off. You don't just get to ignore somebody when they have a claim on something and claim you didn't know that they had a claim on it and you thought it was your claim. He knew what was going on. He didn't want to hear it. And he wanted to continue being on that property that he knows that he didn't have a claim for. And with that, I'd ask this court to find him guilty of criminal trespass on that day, knowing that he had previous contacts with the victims and decided to just ignore them. Thank you, Your Honor.
Mr. Oren.
Your Honor, I think, well, to start with, there's not been any evidence presented really at all that on the date in question, Mr. Livesay was engaged in mining activities in the mine. And under the statute, it's entering unlawfully on real property that is subject to a valid mineral claim release with the intent to hold, work, take, or explore for minerals on the claim release. So there's the issue just of the specifics of the charge. There's a specific date in question. There's no evidence that he was doing that on that date. The other question, though, in this case is clearly a competing claims for who's got the proper mining claim, whose claim was staked properly, whose claim was staked proper in a timely fashion. Mr. Ritter testified that he had staked his claim in September or October timeframe. If you look at the exhibit, State's Exhibit 1, I believe there is no date where it says dated and posted on none of the location notices for the placer mining claim or load mining claim. The date of the posting is not marked there anywhere. They were filed in December with the BLM and recorded in October with the county. That's not really disputable. The stamps are there, but in terms of the exact date of the monuments being erected, it's not. The date is not included on the paperwork, and my client's testimony is, and his testimony has been that he's been on this property since 2012 on a regular basis and never did see these monuments. And when he did see the monument, he found one monument with the airtight, waterproof container with the mining claims that was a far enough distance away from the what's called the Golden Rule mine that he was attempting to stake a claim on, that he did not believe that it encompassed that monument was proper to encompass that mine, so that he could claim that particular mine, and the mining claim that was claimed by Mr. Ritter with that monument would not include the Golden Rule mine because of its location. So there's a dispute of fact about who properly staked the claim, and that is not really a question for this court. That's a dispute over proper mining claims, mining claim dispute. So under his claim, he had under my client's claim, he had the right to be at that property, and being BLM property, hunters and so forth, everyone could be in the area across that property as public land. It's a question of whether or not he was mining on someone else's mining claim, which there's no evidence that he was doing that, for one, on the date in question, but also that he had, I guess what we would call a civil claim, that he had a proper mining claim to be there. Then that's not a question for this court. So on those two bases, I would say that the charge of criminal trespass would not apply in this situation.
Anything else from the state?
No, Your Honor.
Okay. All right. A lot of things going on in this case. One thing is for sure, the court is not going to decide whether or not who had proper claim or who posted properly and things like that. Now, I can't tell you if this was a repeated thing where Mr. Livesay kept going out there and kept getting criminal trespass. Maybe at that point the court would have to look at it and say, okay, well, who has the proper claim to be able to find out if somebody's trespassing. Right, no dispute on that the land is BLM. Prior to the incident on the 9th of 2015, Mr. Ritter claims to have had a conversation with Mr. Livesay. He was there. Livesay said, "Yeah, I'm mining, doing this." There was no proper claim at that point. The statute says a person commits criminal trespass in the first degree by knowingly entering unlawful on real property that is subject to a valid mineral claim or lease with the intent to hold, work, take, explore for minerals on the claim or lease. So in the date in question, Mr. Livesay was not found in the mine. Nobody is required to sit and talk to anybody. If somebody walks up to you, you don't have to talk to them. I mean, you don't have to talk to a police officer, not doing anything criminal. And you can walk away anytime you want. Now, there was things found inside the mine. Mr. Livesay said before the date of the 9th he had been in there and he had taken samples, and that's for the reason for the chemicals. But that could have been done before the 9th. So since Mr. Livesay received this ticket, he says he's been out there, but to relocate bees, hasn't been in the mine to do anything. We have no evidence that shows that he was in there doing anything like that. So the court, at this point, the state finds that the state hasn't met the burden of proof and is going to find Mr. Livesay not guilty of the criminal trespass. All right, thank you.
All rise.
Actually, need the evidence for the
Thank you.